We'll let the record reflect that Mr. Kamen has handed to the Zoning Hearing Board a motion to quash for lack of standing Range Resources Appalachia LLC's challenge of validity of Ordinance 5-2010. Again, Mr. Kamen, you have the opportunity to present your position with regard to this motion.
Thank you, Mr. Ady. The second preliminary motion that we have is a motion to quash for lack of standing. Specifically, what we are asking for in this particular motion is that the appeal be, should the board determine that they have the ability to proceed, which again we believe the board is not legally competent to do so. We are asking that the application be quashed for lack of standing. Specifically, the municipality's planning code section is codified, I should say, is 53 PS 10916.1 governs validity challenges. In order to bring a validity challenge, you have to fall into one of two buckets. You have to be either a landowner or you have to be a person aggrieved. Range in its petition has filed, it appears sort of under both categories, so let me deal with both of them so it's clear for the board. We do not believe that they qualify as a landowner under the NPC because they have pled that they are merely a lessee. In order to go ahead and to bring this challenge as a lessee, they must produce their leases that show that they have the legal right to proceed in this matter. Filing mere memorandums of lease or going ahead and filing instruments that are contained in the county records are not sufficient to go ahead and to confer standing upon them under the NPC. Again, the law and the cases that we have cited say that they must affirmatively produce these items to show that they have the right to be here. At this point, as they have not affirmatively produced these items, we believe that they are without authority to proceed, without an authority and legal standing to proceed in this matter as a landowner. So the next box that they could fall into or bucket is what we call a person aggrieved. And for the record, that's under 53-109-16.1B of the municipality's planning code. In order to be a person aggrieved, Range has to go ahead and basically prove that they are somehow aggrieved by the use of the land of another. We think that this is impossible for them to go ahead and to prove since there's been no use of the land of another that has gone ahead and implicated them or interfered with their rights in any way. So from that standpoint, they do not have standing to be here tonight. I'm not sure when they would have standing to be here, but I can tell you that it is inappropriate for them to proceed on this challenge. Any questions on that one? Because we have another one.
No questions on that. We'll let the record reflect that the Zoning Hearing Board has just been handed a document entitled Motion to Quash Premature Appeal of Range Resources Appalachia LLC, as there is no case in controversy ripe to litigate. Again, you can provide an overview of your motion.
Thank you, Mr. A. The third preliminary motion that we have is what we call a motion to quash the premature appeal of Range Resources. The heart of this motion is that Range has not filed an application as they are legally required to do under the municipality's planning code, and therefore the issue is not ripe for adjudication by this board if the board were to be, again, deemed to be competent, which we are not waiving in any way by proceeding in this matter. Specifically, the law that surrounds this is well-founded, well-established, and basically says that until an application is filed, the applicant has no ability to know how the ordinance would be applied to them. And since the applicant has no ability to understand how this ordinance would be specifically applied to them, they have nothing to complain about. The case is not right. This is a fundamental tenet of law. This is what the court calls refusing to issue advisory opinions, because again, it's a ripeness issue. And specifically, so that the record is clear, and I hope I'm speaking slow enough for you, but specifically so the record is clear, it is our position that this board is without any jurisdiction to hear this matter until an application has been filed and adjudicated. And as such, again, if we would ask that this board go ahead, or I should say a competent board, go ahead and dismiss their application as premature because this board is without jurisdiction to hear it. Just to be very clear, we believe that there is one set of laws, and the laws apply universally. And because of that, Range has to follow the same rules as everybody else. So that's my third preliminary. Mr. Eve, at this point, that is all of our preliminary motions. We would ask that they be dealt with preliminarily so that we can go ahead and decide how we're proceeding in this matter. Thank you.
Okay, thank you, Mr. Cameron. Mr. Kamarowski, are there any preliminary matters that you would like to bring up before we ask you to address the ones raised by the township? Do you want to address the three motions now, or do the board, I think we should probably take a brief recess in executive session so I can counsel the zoning hearing board on the motions, and while I'm counseling them, you have an opportunity to look at them, and then when we come out, you can make some comment regarding those, or would you like to make that comment now?
If I can make just some initial comments.
Sure, please.